The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated.
Our stuff's in, we need to reverse ourselves, you and I.
I'm supposed to be over there. We've got backwards, Chief.
Sorry.
We don't even know how to get the court.
No, we're fine. Are you all right over there, Judge King?
I'm fine.
Okay.
Is that all right?
Yeah. I've been promoted.
Well, they got the names right.
Uh-huh.
Is that all right with you, Judge Wilson?
All right, we'll be pleased to hear an argument in our opening case. And Mr. Williams.
Thank you. Good morning, and may it please the court. My name is John Williams, and I represent the appellants in this case. The essential position of the FTC on this appeal,
I'm pretty sure you're going to need to speak up or speak more into the microphone.
usually not a problem, but I'll do that.
Uh-huh. Thank you.
Let me start again if I could. The essential position of the FTC in this case, in this appeal, is that the appellants are entitled to no relief because they are bad guys and can't be trusted. Because they were found to have engaged in consumer fraud and assessed a penalty of $120 million. A penalty that was based upon the assumption that the property that they sold down in Belize was worthless. $120 million of worthless property. That was the judgment of the court below, and I cannot dispute that finding because that judgment was affirmed by this court. But what I can point out, and what brings us here today, is that the FTC and the receiver have since determined, since the last appeal when we were here, that the property was not worthless.
Now, we're here under an abuse of discretion standard.
I think so.
And the question is whether Judge Masidi abused his discretion
Yes.
in failing to lift the asset freeze.
And in failing to get,
Why would he
excuse me,
want to lift the asset freeze in light of the fact that the receivership was established for the benefit of the defrauded consumers, and they haven't received, as far as I can tell, a penny of it. But what you want to do is to transfer management of the assets from the professional, from a professional receiver and a professional auctioneer, and turn them over to Mr. Pukke with his extensive history of fraud. Why would Judge Masidi wish to turn over the assets to someone whose history of defrauding the consumers would mean that they would not receive a penny? He was put in jail. He was criminally prosecuted for concealing his assets.
Your Honor, may I respond?
Yeah.
We are asking for something else as well, which I would like to get to right now. We're asking for an accounting, which doesn't require Mr. Pukke to touch the assets.
But does that answer Judge Wilkinson's question?
The answer to the question as a legal matter, Your Honor, is that the judge did not make the requisite findings under Kemp. But I would like to get beyond that, and I would like to go to my principal point here today.
You know, Judge Masidi has lived with this case a very long time. And if I might say, I think he's done a pretty good job with it, given all that's been thrown at him. But he made findings that Mr. Pukke had been involved in extensive fraud, that he had misstated the amount of debt of his project, that he had exaggerated the existence of the amenities in his project, that he falsified the timeline of development, and that he misrepresented the resale value of the lots. On top of that, he was conspired to hide his assets so that they would not be used to make the consumers whole. And he was incarcerated for that. And in light of that history, you want to displace a professional receiver who could have hired a professional auctioneer to give the consumers some redress for the way in which they have been defrauded. And you want to take it out of the hands of the receiver and the auctioneer and put it into Mr. Pukke's hands, which will mean they would probably never, the defrauded consumers would probably never receive a penny of it.
Your Honor, may I respond, please?
Yes,
We have asked
can
for
respond.
that,
I'm not
yes.
sure what the response is in this.
We have asked for that because
particular
he didn't make
case.
the right findings. You can send it back down to Judge Massetti, and he would probably make those findings, and we couldn't get the money. I get that. What I'm here to say is something different, please. The basis of the
The judge made those findings that Judge Wilkinson just recited.
yes.
You have to deal with that.
No, I don't, Your Honor. Can I finish, please?
So you accept those findings?
Yes, I have to. This court has affirmed them. What I am here to say is that since the affirmance, the receiver has now and the FTC have now acknowledged that it was not worthless property. They have now acknowledged and they have stated that the property had at least 65% of the value. That is my essential point. And let me just finish up on that point.
Did they acknowledge that below, before
Yes.
the district court, prior to the district court making the findings that were just recited by Judge Wilkinson?
No, that was after, Your Honor. That was after.
So this,
We were up and then we went back and we're into this redress plan now, okay? And they have to determine how much to give to the consumers. We get that. We get that we're liable for
Have they
120.
received a penny yet from
Yes.
these assets?
Yes, they have.
Well, the FTC says they have not.
They've received $10 million in redress.
10 million of the 120?
Yes. Because the receiver,
That's not even 10%, is it?
may I finish, Your Honor? Yes, of course it's not.
you know what would maybe be more helpful to your argument is if you address the concerns of the court.
I
'Cause
understand.
We're trying to get at things that we're concerned about in the case, and we understand that you want to say what you want to say. We want to hear that too.
I am
But
conceding.
you're a little, I feel like you're a little combative with the panel.
I'm sorry, and I apologize for that.
Thank you.
What I'd like to say is this.
And Judge Thacker is exactly right. The concerns of the court are that you're asking a fox to be put back in charge of the chicken coop.
No, I'm not, Your Honor. I acknowledge that he will probably never be put back in charge.
Did you you ask in your brief that the receiver be relieved or that there be
I
audited or
understand,
something?
Your Honor, and that was a step to get where I am going. I understand you're not going to grant that. I'm asking for an accounting. I'm asking here simply to acknowledge that we have a situation where the $120 million, the assumption has been it with worthless property. It is not worthless property. It is 65%. We have an Alice in Wonderland looking behind the glass system now where the assumption was that the property was worthless.
So you're saying
Yeah.
that now that now that you say the FTC has found that the property is not worthless, that
Yes.
it's some 65%,
Right.
that there should be a reaccounting of what the fine was?
No. I am stuck with 120 million.
Okay, what is the accounting?
Because the 65% valuation is an acknowledgement that there is plenty of value that the consumers received. And there are a ton of unsold lots down there that also have significant value. And my simple point here today is that we have a $120 million judgment that we would like to pay off. And the receiver can keep it. We don't need to touch it. All we are asking for is that that property at this point be valued. We have
You've got a judgment out there.
We'll
and
pay it.
The assets are meant to secure payment of the judgment.
I agree.
And there's a $120 million judgment.
And the property is
Right,
worth,
from the Ameridet case. It's $120 million, and the whole idea of a receiver is to secure payment of an outstanding court judgment.
And that-
That's what the receiver was set in place for. And how does it further that purpose to secure the payment of the judgment by putting the person in charge who defrauded the consumers to begin with? And it's inconceivable that we would put Mr. Pukke back in charge of the assets when the judgment has not been paid, and when he has a history of concealing his own assets, of misrepresenting what the property he was offering involved. I mean, this would, and it would
I'm
not
not
only
arguing
undercut
that.
the receiver, it would undercut this court's prior decision. It would undercut Judge Mercedes' efforts to bring this case to something approaching a conclusion, and it would undercut the ability of the consumers to receive a single cent from these assets.
we have an alternative request, Your Honor. The request is for an accounting. We believe, and we have put in affidavit support, that the value of this property is well above $120 million. As the FTC has said, and as we quote, this is nothing but a collections case at this point. And if it turns out that the value of the property exceeds $120 million, it is conceded that we will get that back, even if we're bad guys.
Judge
And
Mercedes made no finding along those lines.
that we would get the money back? I can't imagine that he has any basis to disagree with that. If we have assets
That's
worth,
your only request today, is that you have an accounting.
yes,
That's all. The receiver does an accounting.
Yes.
And you didn't request that of Judge,
oh, no, that's
Steady.
not, that is not right, Your Honor.
you did request that of Judge Mercedes.
Absolutely.
And he turned it down.
He turned it down.
So the only issue then today is whether Judge Mercedes abused his discretion in denying an accounting.
Correct.
And that's the only thing on appeal.
That's right, because
Okay.
you have indicated how you would rule
There's
everything.
one question here.
Yeah,
That's the result. The whole case comes down, all you have is one question.
today I do.
Was there an abuse of discretion in denying an accounting?
Because of this, Your Honor, because we believe the accounting will show that there are assets well more than $120 million, okay? Number one. And we're entitled to then receive that money, pay off the judgment. Or he keeps the judgment and then we get the excess. The FTC says we didn't ask for it. That is flatly wrong. If you look at page 14 of our brief, we talk about how we asked for a calculation of the amount of everything seized, calculation of the amount the consumers have already received by virtue of not having to pay for their valuable lots, and a calculation of the amounts we owed. That's what we asked for.
In terms of even setting aside the extensive history of fraud, isn't there every reason to believe that a receiver and a professional auctioneer and the receiver himself would do a better job managing these assets than Mr. Pukke would do? Just
I'm not
from a
asking-
standpoint of administration, isn't it good to have a fund that has been set up to reimburse the consumers here? Isn't it best to have it under the most professional management possible? And when you compare Mr. Pukke's managerial ability and history in comparison to the receiver and what the receiver could bring to the management of the assets, it's no contest.
I have conceded that point. I'm asking for an accounting. The other
Your
point,
argument today is basically boils down to the last
Yes.
3 paragraphs of your
yes,
brief.
yes.
I understand.
And I would like to say one other thing I
Does the
understand.
government concede that the government, the FTC, concede the point that you requested an accounting?
No, they don't. They say
Then that's on appeal.
yeah, that is.
They don't even agree with what you asked for.
Well-
You say that's the only question is whether you're entitled to an accounting or should have had an accounting, and the government says you didn't even ask for one.
I understand, and
So there's 2 questions.
Okay,
Did you ask
that's
for
a
one,
question.
and did you get it?
And the other question is, they also say that they have provided the accounting. If you look at what they say they provided, which is a cash statement at Joint Appendix 521, all it is a cash statement.
Thank you,
They have
Counsel.
not done an accounting. My time's up. Oh,
Thank you.
thank you.
Mr. Aiken.
May it please the court, Ben Aiken for the Federal Trade Commission. 2 years ago, this court labeled the sanctuary police scam dishonest to the core and described appellant's conduct as the sort of deception that lies at the heart of what the FTC is empowered to seek out and stop. I take it from the panel's questions that they have a firm grasp on the stakes at this point. Mr. Pukke seems to concede that return of the property would be inappropriate, so I'll just jump to the accounting. The defendants...
We have been hit by all these intermediate appeals and these interlocutory appeals in this case. And there comes a point, it seems to me, where we ought to let Judge Masidi manage the case. He's done a pretty good job. He's indicated an understandable frustration with every move that he's made of an interim nature and an interlocutory nature has been appealed up here. And there comes a point in time, it seems to me, where you let a district judge who's had a long history of managing this case, let him continue to manage this case without us jumping in and interrupting what he's trying to do at every turn. And Judge Masidi has had his eyes focused on the fraud and the redress of the consumers who were defrauded. That's his purpose. It's a salutary purpose. It's a correct purpose. And the question is whether he should be given by this court some backup to what he's trying to do.
I certainly agree with all of that, Your Honor. We would welcome an end to the ceaseless appeals in this case. We would welcome an end to the case in general and to allow the receiver to finally sell the land, redress consumers.
And what about the opposing counsel says that the FTC is conceded that the property is not worthless. Do you concede that?
So a few points in response to that, Judge Thacker. First, we never argued that the property was worthless. It's real property in Belize. It obviously has some value. We do not concede that it has 65% of the value. So what?
And when you say 65% of the value, you're talking about the 120 million?
I'm frankly not sure what 65% would even mean. I think opposing
Was
counsel.
it 65% of what? That's all I'm asking.
So the receiver has determined, based on a number of factors, working with the FTC and the Bureau of Economics at the FTC the Bureau of Competition, that consumers should pay 65% of the original purchase price. It is not the case that the land is actually worth 65% of what they bought. The receiver has to balance a number of factors to both sell the land. That will determine how much the land is worth. I don't think there's any question.
Isn't that what appellant wants, an accounting?
I take it at this point that that's all they're seeking is an accounting. For a few reasons, there's no reason for an accounting or any reason this court should order an accounting.
First of all, is it your view that they did or did not request an accounting from the district court?
Our view is they did not request an accounting from the district court. They put it in the proposed order that they submitted.
So that issue is not preserved.
That's correct. That issue is not preserved. Now,
So is it your position that we don't have a jurisdiction?
so our position is that you don't have jurisdiction because there's no standing in the first place.
Well, I know that you brought up standing, you briefed that, but is it your position that we don't have any jurisdiction because there was no preservation of any issue?
I don't think it's a jurisdictional question, Your Honor, that the court can always excuse a forfeiture, but we do believe that they did forfeit.
How do you appeal something that you never asked for?
Well, you can always argue, I suppose, that there's clear error. There's some reason that the court should excuse a forfeiture, but they did forfeit the issue because they didn't include it in the brief. The only thing they can point to on appeal is that they included a sentence in the proposed order.
Wasn't Judge King correct when he said that the real question before us was whether there was an abuse of discretion on the part of the district judge in refusing to lift the asset freeze? And a lot of this stuff, I think I'm hearing for the first time, but what I'm concerned about is that there is an outstanding judgment. There is an outstanding judgment, and it was $120 million, and not a penny of that outstanding judgment, as I understand it, has been paid to the consumers. And the receiver was put in place to secure that judgment and to make sure that they got something back from the way in which they had been defrauded. And so I think, as I understand it, when the question before us was whether there was an abuse of discretion in failing to lift the asset freeze. When the asset freeze was put in place to ensure the satisfaction of an outstanding judgment.
All of that is correct, Judge Wilkinson, with one small caveat. Opposing counsel referred to the $10 million that has been distributed to the consumers. That $10 million did not come from these appellants. It came from a settlement that the receiver was able to achieve with a third party, with a bank in Belize. It was actually, they collected more than $10 million. Some of that money has been spent to maintain the property, and then another $10 million has been distributed to consumers. So at this point, the individual appellants who are on appeal here, you're correct, they have not submitted a penny to the receivership. And you can see that JA 393 and 398, there's a declaration from the receiver that says all the assets that they have, cash assets, non-cash assets, none of that has come from the individual appellants. So Your Honor is correct. There's an asset freeze and receivership in place to secure that $120 million contempt judgment. Appellants have not paid any of it. It was certainly not an abuse of discretion for the district court to prefer that a receiver, rather than the appellants, sell that property.
The question is, what actions are best, have the greatest likelihood of making sure that a court judgment of $120 million, that at least some of it is returned to the people who were, to whom the misrepresentations were made. And it really goes, I think, to the court's authority to try to secure payment of the contempt judgment that is still outstanding. As far as I can see, none of it's been paid.
You're correct, Your Honor, that there is no abuse of discretion here for the district court to prefer that a receiver, rather than appellants, sell the property and achieve as much redress for consumers as possible. You're also correct that these appellants have not paid a single penny to the receiver. If there are no further questions, we ask.
I want to know what do you want us to do?
I would,
Do you want us to affirm
yes.
Judge Bassetti? I thought you wanted us to dismiss. You claimed there's no jurisdiction.
Well, you are correct, Your Honor. We don't think that appellants have standing in the first place to bring this appeal. But even if there is standing, that we want you to affirm the district court's order. I'm happy to address questions about standing.
Jurisdiction they want us to affirm, but I thought your first position was you didn't want us to agree we have jurisdiction.
So absolutely, we don't think that there is jurisdiction here because appellants do lack standing. For whatever reason, appellants adopted the strategy that the individual appellants who do not own the property that they are seeking to have returned brought this appeal, while the corporate defendants who actually own the property decided not to join the appeal and instead brought a separate action in the Court of Federal Claims. Appellants do not meaningfully dispute any of those facts here. They say that the reason they nonetheless have standing is because we argued below that they control the assets. It is true that they control the assets. That's why those assets were subject to the receivership and asset freeze. But control and standing are two different doctrines. Appellants do not dispute the cases we cited that a corporate officer does not have standing to raise arguments on behalf of the corporation. A shareholder, even a sole shareholder, does not have standing to assert the property rights of the corporation. And that is the standing that appellants claim to have here. They were ordered to turn over these assets because they are the corporate officers or the shareholders of the relevant corporations. But those corporations did not join this appeal. So we do not.
Wouldn't it be simpler to just say there was no abuse of discretion in declining to, this case is complicated enough as it is, and wouldn't it just the simpler, straightforward way to do it, say there's no abuse of discretion in declining to lift the asset freeze?
We certainly do not object to Your Honor holding that there was no abuse of discretion in affirming the district court's order below.
Thanks.
If there are no further questions, we ask that the court affirm, dismiss or affirm.
Mr. Williams?
Two points. Number one, this issue that we did not include the request for an accounting in the briefs and that we did not ask for it below is flat out wrong.
I see it in the briefs. Where in the record did you ask for it below? Because there's not a JA site in the briefs that I can see.
Yeah, I believe there is, Your Honor,
Okay,
JA 470 and JA 471. And
All right.
if I am mistaken on that, I will send you a letter.
470 and 471.
Right. And then secondly, this issue about the consumers have received no redress from us.
Oh, that's the proposed order that
Yeah.
opposing counsel mentioned. So that's the only place where you raised this accounting with the district court below was in a proposed order?
Yes. And I
Okay, and you think
I believe we also had it in the brief, but I will check on
It's
that.
in the brief.
Yeah.
I mean, your alternate argument is in the brief.
Yeah.
But you think that just putting it in a proposed order to the district court below is sufficient to preserve the issue for appeal?
I do.
All right.
Secondly, let me come to this issue about how we have provided no assets that have gone to redress. That is correct. And that's really the reason I am here, because the property sits now with the receiver. The property, we have put in an affidavit saying it's worth approximately $300 million. Title to all the land, all the unsold lots, et cetera, the improvements, the hotel we built on it, everything. It has value. And all we are saying is we can pay off the $120 million when the receiver does sell the property. It is not our fault that the receiver has not taken the action yet to go through an accounting. They say in their brief that they did an accounting, and I mentioned that before. You can look at that supposed accounting. It is a cash flow statement. It is not an appraisal or an accounting of the property. And Your Honors, all we are asking for is pretty simple. The receiver has already spent $21 million administering this estate. What we are asking for is that they do an appraisal, they do an accounting, they figure out how much the assets are worth, then they do the redress, and if there is any money left, it should go to the appellants. Thank you very much.
All right. We thank you. We will come down and greet counsel and proceed into our next case. Come on. Mr. Spurgeon?
Drop something, Your Honor. Let me find it here. Here we are. May I proceed, Your Honor?
Please proceed.
Thank you, Judge. Good morning, Your Honor's counsel. I'm Stephen Spurgeon from the state of Texas. I'm here to represent Sergio Murillo for, I guess, my second trip to visit you folks. And thank you for the opportunity to be present. This, as two of the panel members know, is a post-conviction writ brought under Section 2255, alleging bad immigration advice under Padilla versus Kentucky, and the ineffective assistance of counsel standard under Strickland. The court, of course, is very aware of the two prongs that are available in Strickland and is aware of the procedural history of this particular case. Briefly, Mr. Murillo filed a post-conviction writ timely with the district court in Alexandria. The district judge, without a hearing, denied the writ on prejudice only, which is perfectly okay under the Strickland standard, and issued a certificate of appealability on the prejudice standard in light of the recent case at that time of Lee versus the United States.
Going back and recounting all the facts up to the first time the case was here.
Correct.
But we are aware of all of that.
Perfect.
So my question is, do you read Murillo 1, our first opinion, to hold that if an attorney fails to inform a non-citizen defendant that deportation is mandatory or automatic, that constitutes deficient performance?
Absolutely. Absolutely. I don't think you...
And maybe you could explain why.
I can explain why. The language, first of all, let's look at the language of the case. The language of the case presumes that you have to find, not presumed, it expressly states, in order to find prejudice, it has to be based upon the lawyer's performance. And I was thinking about this morning, how to give you an example, and the best example I might can give on this, and it's not, It's not great, but it fits from where I'm from. And this case is a little bit like a Sunday afternoon bull riding event at a rural West Texas rodeo arena. You've got two prongs. The prong is the bull. Now, these bulls are trained to be mean, and they're trained to spit, and they're trained to fight, and they're trained to wiggle and do things that bulls that are out in the pastures don't do.
Now, I do like to watch the PBR sometimes. However, I think your best argument here is the case law. Swaby
Well,
and
Swaby stands for the position that, of course, that the plea agreement isn't controlling on prejudice. But
Swaby stands for the position that the counsel needs to advise the client that deportation is categorically a certainty. And when this case went back, there's no new evidence that counsel did inform Mr. Murillo of that, right?
In fact, they did not. They did
said.
not. Let me address that precisely, okay? There was an affidavit or a declaration that was provided in this case, first time it came here from defense counsel, JA 101, where the lawyer says at no time that I provide Mr. Carrillo with immigration advice.
How do you get around the plea agreement?
Pardon me?
You can't get around the plea agreement.
I don't think
You can't get around, you haven't mentioned the plea agreement yet.
Well,
You can't get
Murillo
around the
gets
plea
around the
agreement.
plea agreement.
Read the plea agreement.
I'll go to
This fella confirmed that he wished to plead guilty. This is in quotes.
What
To-
did Murillo
To
want
plead
to say
guilty
about it?
regardless of any immigration consequences that his plea may entail, comma, even if the consequence is his automatic removal from the United States.
Well, Your Honor,
End of quote.
That's correct.
That was in the plea agreement
Yes.
that you and him signed.
I didn't say it.
He did.
Well, you're the counsel. You're the only one we got here. His counsel and the defendant signed that.
Yes, Your Honor. May I respond?
That's the plea agreement.
But who?
And the court accepted that.
Yes, it did. But let's get to that
The
point.
district court did. What did Murillo 1 say about the plea agreement? That the plea agreement could not bear the weight that the government was trying to place on it.
Your Honor, let me address this.
Okay, I'm trying to help you, but will not be helped.
For giving immigration advice. The plea agreement and the judge, or should the lawyer be responsible? And let's talk about what happened to the defense counsel on this case from the transcripts when we had the hearing with Judge Tringa.
You talk about what's happened to who?
Let's talk about the transcripts from the
Talk
evidentiary
about
hearing
what happened
before
to
Judge
somebody.
Tringa when it was remanded back to discuss the ineffective assistance of counsel. Justice Stevens clearly says it is quintessentially the duty of the lawyer under the Sixth Amendment to give accurate immigration advice of immigration consequences. Boilerplate law.
And his lawyer advised him to sign the plea agreement.
Well, let's talk about, here's the questions.
They both
I
signed it.
asked Ms. Martell regarding her signed declaration that, quote, at no time did I provide Mr. Carrillo with immigration advice. I asked her on the stand. I said, Ms. Martell,
And that was sworn to before the judge.
this was before,
The plea agreement.
this hearing was done. And I asked Ms. Martell, is that true? Is it true that you didn't give any advice? And she says, that's what it says there. That's correct. And I said, is that truthful? Is it truthful when you said that? That's a yes or no. And Ms. Martell said, I believe I did. And Judge Tringa jumped in. And he said, I'm sorry, you believe he did what? And I believe it was
Judge
truthful.
Wilkinson's trying to interrupt you.
Yes.
Right here.
And then the government counsel.
Wilkinson has a question.
All right, you go ahead with your argument. You go ahead. I will rescind my question.
Then the government counsel asked the question, did you give immigration advice? She says, I would say no to that. They ask it again. Did you provide immigration advice regarding Mr. Carrillo's
You
immigration
need to
status?
understand that when you come to court in Fourth Circuit, you don't interrupt the presiding judge.
I apologize. Wasn't my intention to interrupt. I got carried away and didn't hear the
I
voice.
will try to overlook your rudeness.
Thank you, Judge. Your question, sir.
Let me ask this. Why, as a practical matter, would you want the plea agreement rescinded if the ultimate consequence is going to be that he's going to be facing trial with a substantial amount of evidence against him. And if he's convicted, there is a mandatory 5-year minimum. And it seemed to me in light of that, that the lawyer negotiated a pretty good deal and helped him to avoid a 5-year mandatory minimum. And I'm wondering if we can find, just on the performance prong, ineffective assistance of counsel when the result achieved is seemingly, as a practical matter, favorable and beneficial to the client.
Your Honor, it's a pretty good deal if you're a citizen of the United States, and after you serve your prison time, you get to go back home to your family. Not a good deal when you're looking at banishment forever.
If you prevail here, you're going to end up getting him in prison for a longer time.
No, we're going to have it.
And that's right. You're the next one that'll be.
Didn't Murillo
Ineffective
1
counsel.
answered that question already? Murillo 1 found prejudice and assuming deficient performance, and assumed that if the counsel did not advise him that deportation was mandatory, then that would be deficient. But we need that factual finding. So prejudice has already been established by Murillo 1, correct?
And under the mandate rule,
Okay.
Judge Trinkus held to that.
So the issue for the district judge on remand was the performance prong.
Ineffectiveness.
And he found that there was no deficient performance.
But you can't get
So the issue on appeal is whether to affirm or reverse the district judge on the performance prong.
That is the issue. That is, and
If he wasn't entitled to assign it, we couldn't, to decide it, we couldn't send it back.
well, he was.
Why do we send it back if we're not going to let him decide the issue?
What was this?
We remanded it. The court remanded it to have him decide it. He's decided it. Now the question is, do we affirm or not what he decided?
We remanded to have the evidentiary record developed as to whether or not the counsel actually told him that he was categorically deportable, as is required by our precedent in Swaby. Is that correct?
Correct. Strickland provides that a judge can skip the first prong on ineffective and go right to prejudice. And it doesn't matter whether the lawyer was ineffective or not if there's no prejudice.
Yeah, but our court remanded it to have the district judge find the first prong.
Right. But,
Decide the first prong.
but the first prong is limited to the language of the court opinion that was sent back to him, where prejudice, because you can't get the prejudice if the lawyer wasn't ineffective. It's built into the whole definition.
Well, no,
of
we
the second
didn't.
prong.
We didn't. In Murillo 1, we did not find that the lawyer was ineffective. We assumed ineffectiveness and remanded it for a development of the factual record to determine if what we assumed happened did happen. And the record appears to bear out that what we assumed happened and would be deficient did happen. Is my understanding of that correct?
It is correct, Your Honor, and the record below leaves, to quote this court, little doubt that avoiding deportation was appellant's main priority. Not the sentence, that's always a factor, but his main priority was to avoid deportation. And Chief Justice...
That's not what the plea agreement said. The plea agreement that he, when he pled guilty, and this is a drug smuggler we're talking about, a drug smuggler, a confessed drug smuggler that you represent. And he wanted to plead guilty regardless of the immigration consequences, even if the consequence is automatic removal from the United States. That's what the plea agreement says.
Boilerplate
And that's
language.
plain English.
Boilerplate language doesn't impact prejudice, and it certainly doesn't impact whether a lawyer was ineffective. particularly when this court's already found prejudice.
Prejudice was found in Murillo 1,
Prejudice
so
is
we don't
found.
need to talk about that. It's the first prong that we're all
I
talking
mean,
about.
Judge King, you asked the question of what happens if it gets remanded back, if you guys make a decision and it gets remanded back for a trial. Well, Chief Justice Roberts addressed that in the Lee decision. Sometimes a Hail Mary pass is appropriate. Sometimes even against overwhelming evidence of guilt. Sometimes against a longer prison sentence. A defendant's willing to throw a Hail Mary pass to remain with their families when they have a shot to remain with their families, a shot not to be deported for life, a shot not to be banished from a country they've lived in since they were 7 years old.
What all you're saying is contrary to the plea agreement, to what I just read to you.
Well, I'm saying,
Even the immigration consequences he will accept, even if the consequence is automatic removal. That's about as explicit as you can get.
but doesn't it appear in every plea agreement?
Well,
Whether you're a
well,
citizen or not?
What appears in Murillo 1 is, quote, "We hold, however, that a single line from a plea agreement cannot bear the weight the government would like. Appellant demonstrated a reasonable probability that had he fully understand the implications of his guilty plea, he would not have pled guilty." And that is why we held that there was prejudice.
Correct. And Judge King wrote a beautiful dissent that was well
Thank you,
written.
counsel.
That's all I've got. Thank you.
He always does.
Yeah. But politely as well. I'll sit down.
Not everybody agreed with that.
Ms. Bashara?
Good morning, and may it please the court. Jacqueline Bashara for the United States. As I understand my friend's argument, he is not contesting the district court's factual findings after the evidentiary hearing as to the substance of defense counsel's communication to her client.
No, because the district court, because she never, our counsel below never advised appellant that deportation was mandatory or categorical as required by SWABI.
So I agree with you as to the factual point. She did not tell him that deportation was mandatory. So the question for the court in resolving the performance prong is whether that was objectively reasonable, consistent with Padilla. The government's position is that it is, because her warning that he would be deportable, removable, and subject to immigration deportation proceedings after completing the service of his sentence was
If the,
sufficient to put the defendant on notice.
Let me ask you this. If the attorney had advised and said that deportation was mandatory, would that have been an accurate statement? Because the Attorney General in the Department of Justice always has the discretion of canceling removal or canceling deportation for a variety of reasons. I mean, there's ultimate discretion is lodged in the Department of Justice, and so I'm wondering if the statement that something is mandatory, I'm wondering if that's an accurate statement in light of the complexity of immigration law and in light of the ultimate discretion that the Department of Justice possesses. I mean, I don't want to see we don't want to see lawyers meet themselves going and coming and making statements that wouldn't be accurate and then coming up here on a claim of deficient performance. And that's one of the problems that I have. If they stress the mandatory, that the at the end of the road by saying the deportation is mandatory, that would have pushed the individual to trial. And if the individual had gone to trial, then that would have meant a 5-year mandatory minimum. And so given the consequences down the road of a 5-year mandatory minimum, and given the fact that definition of mandatory may not have been completely accurate given the department's discretion. I'm wondering if it's defective performance to achieve a favorable plea agreement and avoid what arguably at least might have been oversimplified or advice. You see what I'm saying?
Yes, if I could respond. So you are right to flag this concern about whether the defendant's proposed warning would actually be correct. At least 3 other courts of appeals, the Fifth Circuit in Armendariz, the Eighth Circuit in Ramirez-Jimenez, and the Seventh Circuit in Chazon all expressed concern that this rule to say that the defendant would be deported, that deportation is mandatory or automatic, would
This rule,
possibly be incorrect.
Where is it a rule?
Sorry?
You say, you're questioning this rule, so it's a rule where?
I'm sorry, the defendant's proposed rule.
Okay.
It's not clear
What
that
does
that would
Swaby
be
say?
correct advice. So I disagree with the suggestion that Swaby made a holding that that is what Padilla requires, because that's not what the court was confronted with in Swaby.
What does categorically deportable mean?
I'm not sure. That's a judicial gloss on the statute, right? But the statute says deportable. The notice to appear that was actually issued to the defendant here, that's at JA 143, it charged him with being removable, right? This is categorically is
And I'm
is
sorry,
not
I did
part of.
interrupt you, and I want to hear the rest of your answer about those other cases in response to Judge Wilkinson's question.
Thank you, Judge Thacker. So yes.
I will point out
Okay.
what Swaby says, effective representation requires that counsel provide correct advice.
Yes.
Correct advice. And what Judge Wilkinson proffered to you would be correct advice under the law. And what the plea agreement said would be correct.
And I think you were about to tell us about cases that also support what Judge King just said.
So
Circuits, 3 circuits, you said.
3 circuits have
3,
recognized.
the 8th, the 9th, which were they?
The 5th, the 8th, and the 7th have
The
said
5th,
that
the
this
8th, and the 7th, you
defendant's
say,
proposed warning
okay.
may not be correct advice because of the room for discretion. I think there's actually 2 levels of discretion, right? There's executive branch discretion that Judge Wilkinson has addressed, but there's also significant discretion on the part of the immigration judge. I know that my friend focuses
And the
on
Attorney General of the
ineligibility.
United States has vast discretion in these immigration matters. The Attorney General. I mean, the immigration courts work for the Attorney General, right?
Well, this
They're
is,
part of the Department of Justice.
this is an aggravated felony of
You work for the
drug
Department of Justice,
smuggler.
all of you, the ones that are negotiating these pleas, deciding what to prosecute. You're all working for the Attorney General of the United States. So, and Swaby says the lawyer has to give them correct advice.
Right. and the
Sure, they have to
court-
give them correct advice. You always want to give your client the correct advice. You always do.
And the district court made a finding that Ms. Martel did not provide any incorrect advice here.
Did the
Unless you had
district
a,
court make a finding that counsel provided correct advice? You said district court made a finding she did not provide incorrect advice. Did she provide correct advice as Swaby requires? Did the district court say she gave him correct advice?
the district court found that she advised him that he would be deportable, removable, subject to immigration proceedings, and that satisfied her obligation under Padilla.
Did the district court say, you said the district court said she did not provide incorrect advice,
Right.
clearly said she did not provide incorrect advice.
Yes.
Did the district court say that she provided correct advice, which is the language from Swaby that Judge King read?
So I don't
No.
think there's a finding to that effect,
Right,
Your Honor.
no.
Could I go back to Judge Wilkinson's point?
Yes.
I know I'm happy to address other questions, but I just wanted to reiterate that we don't have to, or you don't have to just rely on what other circuits have said. We also have 2 immigration lawyers that the defendant presented at the evidentiary hearing who said that they would not give the advice that a defendant would be deported, right? Mr. Reyes testified that he could not make that kind of absolute statement.
Were they qualified as experts?
Then maybe they were deficient.
Go ahead, I'm sorry.
They were not qualified as experts.
Okay.
But they introduced themselves as immigration attorneys.
Well, it makes them an expert, I guess.
Or it makes them deficient, if that's what they
Maybe
told the
make them
client.
deficient.
But please finish.
Okay, I would just add, Mr. Drake said the same, or a similar thing. It's 100% impossible.
The Strickland standard, to come back to the performance prong, in order to be judged ineffective, it has to be well below the professional norm. And, I'm just wondering, as a general rule, when a lawyer secures what on the face of it seems to be a very beneficial result, whether that is below a professional norm, it seems to me that may be seen as a valuable professional service. But I'm nervous about pushing lawyers in the direction of requiring them to say something that would be arguably incorrect, and we can debate that. Because if you say this is mandatory, that you're going to be deported rather than there's a risk of deportation or something, I'm wondering if we would lead clients into disastrous decisions. I mean, they say, we're going to go to trial, and looking at the evidence here, the evidence against this gentleman is pretty overwhelming. If you go into trial, I can't see that he would have stood a very good chance before a jury, and the gentleman would have been given the crimes that were charged if the case went to trial on the charged offenses. He would have been in jail a mandatory minimum of 5 years, and the maximum is way higher than that. And so looking at Strickland, we have to, and the prejudice has been decided, but the performance prong, I really wonder whether this is materially or substantially below the kind of things we expect from attorneys representing clients that may be subject to immigration consequences. I think Strickland requires situations where the lawyer screws up pretty badly. At least that's the way I read the opinion. But this, looking at the whole record, sounded like a pretty good lawyer to me.
Yes. Strickland and this court's precedent consistently admonishes that courts are to indulge a strong presumption that counsel's performance was reasonable. And Strickland also advised against an overly searching inquiry into the performance prong precisely because of the adverse follow-on consequences that Your Honor is describing, right? In terms of unintentionally perhaps forcing or incentivizing defendants who otherwise wouldn't to go to trial because a defense attorney is incorrectly advising that they absolutely will be deported. And the other thing to think about is, to the extent the court is writing a rule about what other defense attorneys have to do in other cases, the Fifth Circuit recognized that in order to be able to state categorically that a defendant absolutely would be deported means that the criminal defense attorney has to basically boil the ocean of the immigration code to make sure that there is no potential avenue for relief. And of course, that doesn't take into account all of these other levels of executive discretion that we have been addressing. And Strickland was particularly concerned about.
Well, as Judge King pointed out, he's a drug smuggler. I don't think the Department of Justice is in the business of just not deporting aggravated felon drug smugglers,
But
are
both
they?
Ms.
On a
Martell,
regular basis?
both Ms. Martell and Mr. Reyes testified that they personally knew of defendants with aggravated felony convictions who were still here in the United States.
Well, probably
And so-
some of them cooperate with the government.
Yes,
in
and there was a
cases-
cooperation
in
provision.
bigger cases, and they get lenient treatment from the Attorney General. The
Yes.
Attorney General's representatives. I mean, there's a lot of possibilities. What you want us to do is what? Affirm?
Absolutely.
Okay? And what's the result of what would result from that?
The
What's that mean?
2255 motion would
If we
be
simply
denied.
affirm Judge Tringa on the
Yes.
remand, is there any other result that we need to consider? What the impact of that is on the first opinion, or what the impact of that is on this felon Murillo? That's not pertinent, is it?
No, because the district
Question
court,
is whether Judge Tringa was right or wrong.
on performance, correct? The district court expressly did
performance
not
prong.
revisit
On the
prejudice.
performance prong as to this lawyer in this case.
Yes,
That's the only issue before us.
that's correct. Unless the court has further questions for me, we ask that you affirm.
Any questions?
Briefly, Your Honor.
Thank you. Come here, some rebuttal time.
Briefly. I'd like to address 2 points, one to Judge King, one to Judge Wilkinson. Judge Wilkinson, you asked the question about the situation with the lawyer. What's the proper advice? Are we going too far? Supreme Court's been clear. They have to give available advice. The advice that's available, that's the quotation from the Padilla case, available advice. In this case, my client Judge King is a drug trafficker. An aggravated felony drug trafficking offense under Section 1001A43B of 8 U.S.C. states that is an aggravated felony. There's a big difference between aggravated felony drug cases and aggravated felony other cases. Alien smuggling, there's a pardon for. Theft, there's a pardon for. Lots of weight, but aggravated felony drug trafficking cases, you only got to look at 3 statutes. You got to look at the statute that says if you're convicted of a drug crime, you're deportable. That's 1237A2AB, I think it is, okay? Under the 8 U.S.C. You got to look at that statute. So if you're not a citizen, you got a drug crime, that puts you in proceedings. Number 2, there's a statute that's 1227A 2 3 little i's. That's the aggravated felony. Any alien convicted of an aggravated felony is deportable. Second statute you got to look at, okay? Third statute, you got to look at what's the definition of an aggravated felony. Aggravated felony under Section B includes drug traffickers. Finally, when you've got these kinds of deportable crimes for a lawful permanent resident, as Mr. Murillo was, he's lawfully in the United States, okay? You can't get a pardon from the Attorney General can't give a pardon if you got an aggravated felony. The rule under Section 240A, that's Section 1229B lowercase a, okay? That's the statute that sets out the Attorney General's being able to grant these things. Mr. Murillo's not eligible at all for this, 0. This is not a hard case to find deficiency based upon these facts, period. You don't got to boil the immigration code. You just got to read the statutes. Any lawyer can read the statutes. And it's not a duty that a lawyer can punt. We've got a responsibility. Maybe it takes a little extra work. Maybe you got to try to negotiate a non-deportable plea, okay? Sometimes you can negotiate a drug trafficking case to, 1546, which is the importation of other goods. That's not a drug trafficking case, all right? It's not an aggravated felony. Other things you can do. So the point I would like to make is that this isn't a hard case to find deficiency. You just got to look at the statutes, read the statutes. Discretion. I think that covered it. Any other questions?
No.
Thank you, Judge. Thank you for having me.
You want to take a break at this point? Okay. We will come down and greet counsel, and then we'll take a brief recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Okay, please be seated. And we're here to proceed with RA versus McLenahan. And Mr. Saint, we'd be happy to hear from you.
Thank you, Your Honor. Colin Saint here on behalf of the school officials, the appellants in this action. I want to note at the outset for the court.
Do you want to speak up for us?
I'm sorry, Your Honor. I want to note for the court at the outset that the alleged bad actor, Ms. Johnson, is not an appellant. She is still a defendant in this case, as is her employer, the board. The question before this court is whether the school officials need to remain defendants in this case, and the answer to that question is squarely no, for two reasons. Number one, the second amended complaint, the factual allegations, like the first amended complaint, do not allege any of the piercing exceptions for the school official's public official immunity. This court in June of 22 carefully analyzed the allegations of the first amended complaint and determined that those allegations do not pierce the school official's public official immunity.
Our earlier ruling was not a jurisdictional or venue ruling. It was a merits ruling, and that was there was an entitlement to public official immunity because there was no intent on the part of the school principal to harm. So it was a straight up merits ruling, not a jurisdictional ruling. And a merits ruling, of course, is presumptively dismissal without prejudice, with prejudice.
That's my understanding as well, Your Honor. And the second reason why these defendants do not need to be defendants anymore is because the district court failed to effectuate the letter and the spirit of this court's mandate from June of 2022. This court very clearly stated the school officials, the claims against the school officials must thus be dismissed. And Your Honor, to your point, that was a dismissal with prejudice.
I mean, I thought this was all relatively simple. It was, Judge Thacker and I were on that earlier appeal, and
Yes.
we issued an opinion, the two of us, indicating that in about as explicit terms as we could possibly make it, that the state law claims against appellants must thus be dismissed, and the district court decision to the contrary must be reversed.
Yes.
And it seems to me that our own, regardless of whether one agrees or disagrees with the ruling, our own authority is at stake here. And the basic question is whether district courts are required to respect our mandates or whether they are not.
Yes, Your Honor, I would agree with that. And the mandate rule is very clear. District courts must respect this court's mandate, which, as you stated, was exceedingly clear. These issues were conclusively decided. We now have the same four defendants that this court ordered dismissed, the same exact claims as admitted by the plaintiffs, that they were not adding any additional claims, only allegations. And that is a violation of the letter and the spirit of this court's mandate.
I've seen some close mandate questions, but this is not, speaking purely for myself, this is not a close case. We told the district court what to do, and the district court did not do it. And sometimes district courts get their back up when they're reversed. And so they look for ways to circumvent what we say. And so I think this is a much more basic question than whether the first decision was right or wrong. I happen to think he was absolutely right. And
Yes,
Judge
Your Honor.
Thacker and I were in the majority there. But quite beyond that, It seems to me the question is whether we're going to sit here and see our rulings disregarded. And if we treated the Supreme Court's remands in the way that our earlier decision was treated, we're in a difficult position indeed.
Yes, Your Honor. And importantly, this wasn't a remand. It was a reversal. This court is very clear when it
We didn't
remands.
remand for further proceedings. When we remand for further proceedings, we make that clear.
Yes.
But, you know, I remember writing the line.
Yes, Your Honor. There are exceptions, as this court is well aware, to the mandate rule, and none of them apply here.
Given all of that, and I'm well aware that Judge Motz's opinion was concurrence, but she did mention in her concurrence, in my view, on remand, the district court should consider rendering the dismissal of these negligent claims as without prejudice to allow RA a chance to amend her complaint. What do you make of that?
I think there's two important clauses of that footnote. Number one, in my view, meaning my understanding is not in your view, Judge Wilkinson, or your view, Judge Thacker. In her view,
Provides a concurrence.
that is my understanding as well. And then secondly, she says on remand, but again, this wasn't remanded, it was reversed. There was no remand here for there to be a dismissal without prejudice. This court ordered it to be dismissed with prejudice, and that wasn't done by the district court. The district court seemed to imply that the parties had something to do. This court is very clear. It's the district court that has to effectuate the letter and the spirit of the mandate, not the parties. There wasn't anything else for the parties to do here.
We have a lot of, everybody writes an occasional concurring opinion. I think probably all three of us have written concurring opinions. And sometimes concurring opinions can be useful, but the controlling opinion is the majority opinion of the court. And that's got to be pretty basic. It's the majority opinion.
I agree with that, Your Honor. None of the exceptions to this court's mandate apply here either. There's no claim of controlling legal authority changing dramatically. There is no claim there's blatant error by this court. The only claim is that there's significant new evidence not earlier obtainable by due diligence. There are two issues with that. Number one, there wasn't due diligence. Plaintiffs have not proven there was due diligence, and they can't, because they made no attempt to obtain what they claim is this significant new evidence until January of 2023, after this court issued its mandate. The law enforcement records were discoverable earlier under state statute 132-1.4a. They never applied to the criminal court, the North Carolina Superior Court, to obtain the law enforcement records. That is a lack of due diligence by plaintiffs and does not meet the standard for an exception to the mandate rule. Additionally, the evidence itself isn't significant. It's not an extraordinary circumstance. It's quite an ordinary circumstance to request the law enforcement records when there is an underlying criminal charge, and the underlying criminal charge here was alleged in the First Amendment complaint. So it's not that the criminal case happened after the First Amendment complaint was filed. It happened long before the First Amendment complaint was filed. They haven't shown that this is significant, and it doesn't change.
There was no finding on the part of the district court that that evidence was unavailable.
That's correct, Your Honor. There is no finding that it was unavailable because it was available. Additionally, I've never seen what the new evidence is that plaintiffs claim is significant. The district court never saw it. This court cannot see it. It's not in the record. All we have are plaintiffs' summaries of what is in this quote-unquote significant new evidence. But the evidence didn't change the landscape whatsoever for these four school officials. There are no new allegations against the superintendent, Mr. Johnson, while GA, the minor plaintiff, was Ms. Johnson's student. There are no new allegations for the special education director, Ms. McLenahan, while GA was Ms. Johnson's student. There are no new allegations against the principal, Principal Kluwer, while GA was Ms. Johnson's student.
I sat on some cases where I dissented. And when the case went back to the district court, or where I wrote a concurring opinion, and the case went back to the district court, and the district court cited either my dissent or concurrence in an attempt to avoid the majority opinion. And I said, and I remember, said, look, no matter, it doesn't matter what I said earlier in dissent, doesn't matter what I said earlier in a concurrence. The majority's mandate is what matters, and I'm going to join you totally and wholeheartedly in slapping the district court down for that.
And I believe that is the correct result in this case, for this court to say, we meant what we meant. These claims must be dismissed against these 4 school officials, and it was error for the district court to allow the same claims against the same school officials to proceed in the second amended complaint. I'm happy to address the allegations of the second amended complaint if that would be helpful for the court to describe the differences. But if not, I'm happy to see the rest of my time.
Let me see if my colleagues have further questions. You have any? We have no further questions.
Thank you, Your Honor.
Good morning, Your Honor. Stacey Gahagan. I'm here with my colleague Natalie Knack, and we're on behalf of RA and her son, J.A. I will focus my comments to you today with regards to the issues that you raised with the mandate rule and the decision that was issued by the majority of the panel in the last decision. So the majority issued the decision, the final part of the decision indicated that it was reversed. Okay? There were no directions, there were no specific instructions to the district court to dismiss with prejudice, to dismiss without prejudice, just that the bottom line was reversed. And when something is reversed, the reversal acts as an annulment, and it sets aside the decision and puts it back where it was before. It's not my understanding that that an appellate court can dismiss a case without sending it back to the district court to effectuate that dismissal. And when, as this court has approved, when an appellate court issues a decision that doesn't have specific instructions, then it's the burden of the district court to look at the decision as a whole, including any concurring and dissenting opinions, and the analysis, and to make the best determination that it can. And that's what Judge Bell did in this case. And based on, after doing that—
I'm just not anxious, frankly, and to me it's a very simple matter. I'm not anxious to sit up here and send a signal to district courts that they're free to disregard the mandate of this court. And there are close cases about that, but this isn't one of them. We could not have expressed ourselves more explicitly than we did in this case. And it's unfortunate from your point of view because now, because of what the district court did, we have a whole nother appeal that was unnecessary had the district court paid basic respect to what we did earlier. We don't need to be here. We didn't need to run the clock anymore.
And Your Honor, if I could just respond to that. I think if you look at the opinion as a whole, and I do want to kind of go to what the bottom line is, which is simply reversal.
What were you talking about when you talk about waiving issues in the notice of appeal?
Oh, Your Honor, what I was addressing with that was that only Mr. Johnson raised that the magistrate chose not to address.
I mean, that's going to, as if the failure to follow the mandate isn't directed at undercutting the Court of Appeals. The whole idea that we're going to have arguments now over waivers of issues in notices of appeal. I mean, I've seen issues waived in briefs, and I've seen issues waived in oral arguments, but I haven't seen a whole lot of, a great many questions about whether someone had waived an issue with respect to the notice of appeal. I mean, we're going to get, that seems to me a very litigious concept.
Well, I'm sorry, Your Honor, the final decision, just in response, the final decision or the final page of the magistrate's recommendation indicated very clearly that that if you wanted the district court to review any portion of the decision
As a
de
general
novo.
rule, I don't know, you waive an issue by waiving it before the trial court, or you waive an issue or forfeit an issue by not raising it before the trial court. And you may waive an issue by not briefing it at the Court of Appeals. But I had not regarded a notice of appeal as a particularly fertile ground for arguments over waiver. That strikes me as strangling our own review.
So, Your Honor, as indicated on JA 927, the last page of the magistrate's recommendation, it cites to this court's decision in Diamond versus Colonial Life, and says that any failure to file objections to any portion of the memorandum constitutes a waiver of the right to de novo relief by the district judge. Moreover, failure to file timely objections will preclude the parties from raising such objections on appeal. And that was the basis of our argument that the other appellants, with the exception of Mr. Johnson, had waived.
Do you have anything further?
Just a couple of more comments, Your Honor, in regard to reviewing with the decision from Shakespeare Company that was from the District Court of South Carolina, which was affirmed by this court, with regard to what district courts are supposed to do when there aren't specific directions on remand. And if you look at the decision that you issued as a whole, I do understand that at the end, what your conclusion was that the claims had to be dismissed. But the crux of that decision was that RA had not made even a bare or conclusory allegation, that she had not properly pled the exceptions to the piercing. And so from that standpoint, when you read that decision as a whole, that was what Judge Bell indicated, that his decision would have been to dismiss it without prejudice and to allow us to amend the complaint as he has permitted us to do. With regard to the issue of new evidence, I do just want to be clear, that evidence was not available to us. We were still trying to get that evidence. It required a consent order from the district court. The record was closed, it was expunged. It's not something that we could just, we tried to ask for evidence prior to that. And the investigative reports that we received allowed us to add additional allegations to support the appellant's knowledge of the issues and the issues that we were bringing before the court to be able to support and bring more heft to the factual allegations in support of our allegations of malice and the actual intent and the corruption.
You're trying to get into the merits.
No, sir, I'm not trying to get into the merits. I'm trying to answer the question about the second exception that Mr. Saint was raising as to why there is not to the mandate rule. To the extent that this court finds, as I believe that you do, that the first opinion was specific and ordered a specific outcome to the district court that the district court did not follow. The second exception to the mandate rule is when there is additional evidence, and that's new evidence that was not priorly attainable. And so I'm answering those parts of the argument as well. And so those are the additional allegations that are in.
You're saying both exceptions apply, or just now the second exception?
So, Your Honor, I think that the second exception is the one that we've argued in this brief as why it doesn't apply, why the mandate rule would not apply. So that was that we did have additional information that we received after we had the protective order from the district court from the sheriff's office. We don't have the rest of the file yet from the district court because discovery has now been stayed. But that initial report, the investigative report from the police, allowed us in the second amended complaint to add additional factual allegations regarding the numerous other reports, admissions from the appellant saying that they had received those reports.
We applied the exceptions. In this case, the exceptions would swallow the rule.
I appreciate that, Your Honor. Those are, from our perspective, the court did not issue a direct instructions. This court has in many, many cases, and I can tell you, I've watched the opinions that come out of this court to see how the language is, and they provide very clear direction, reversed with directions to dismiss with prejudice, or to dismiss without prejudice, or to dismiss as moot. In this case, the only direction that was there was reversed. And when you look at the case as a whole, including the concurrence, and you look at the reasoning, the district court determined that he had the right to dismiss it without prejudice.
Well, I was shocked by what happened here, because I've not seen district courts operate in this kind of fashion before. I was shocked by what the district court did here.
And I note that you disagree and that you felt like that it was very clear. So I think that, if you have additional questions, I don't want to belabor your time if you feel that it was clear and that the district court violated the mandate rule. We contend that they acted within the discretion because there were not specific instructions. Okay.
Thank you.
Okay. Thank you, Your Honor.
Do you have anything further to say?
I'm happy to answer any of the court's questions if you have any. I appreciate the court's comment that continuing to belabor the point is a waste of judicial resources. I agree. We would have to repeat discovery if this court reopened this matter. There's been 8 months that passed between the mandate.
You laid out your arguments in your brief.
Thank you, Your Honor. Then I ask this court to reverse, again, the district court's decision to allow the second amended complaint to continue and make clear that this is a dismissal with prejudice, that these school officials have public official immunity, and the purposes of both the mandate rule and public official immunity are served by this court making that decision. These school officials deserve finality.
We understand.
Thank you, Your Honor.
We'll come down, we'll greet counsel, and then we'll proceed into our final case. Mr. Plackey?
May it please the court, counsel. In this case, the district court abused its discretion and committed significant procedural error by denying the defendant full exercise of his allocution rights. This court should vacate the judgment and remand for resentencing.
What are you asking for? Just that he have a new allocution or what?
That he have the opportunity to present all of the information he had prepared to the judge who sentences him.
But what he wanted to present was not to the judge, it was a letter to his mother.
Yes, the first time he mentioned it, when he gave an overview, he said, I've prepared 3 things. A soliloquy about change that he had memorized in therapy, comments for the court and comments for his mother. Then he later described it as a letter. But it's not uncommon for criminal defendants to address comments to their family during allocution, especially when the family member's present. And it's not uncommon for those comments to influence the court's sentencing decision, one way or the other. So although he characterized it as a letter to his mother, the content of that was still relevant to sentencing.
Did you represent him at sentencing?
Yes, I did, Your Honor.
Did you object to anything?
I did not. He asked 3 times.
You mean he asked the court 3 times to read the letter to his mother? Is that what you mean?
Yes, I'm sorry, I should be more specific. The defendant gave an overview. I have these 3 things I want to talk about. In about 4 pages of transcript, he got through 2 of them. He used the word mercy. The district judge wanted to follow up with some questions about that. The defendant wanted to read the 3rd thing that he had forecast, and he asked to do that. The judge said no. He asked again. The court said no. He asked a 3rd time. The court said no. It's our position under the Lee case that preserves the issue. A defendant who asks repeatedly to say something to the court and is rebuffed repeatedly has, in the view of the Lee court, preserved the issue for appeal. And that's why we believe the standard of review is abuse of discretion. Interestingly, in the Thorpe case, this court cited Lee, not on exactly that point, on a separate point, but acknowledging the Ninth Circuit's decision in Lee. The plain language of the rule is clear. Before imposing sentence, the court must address the defendant personally in order to permit the defendant to speak or present any information to mitigate the sentence. And as I mentioned a moment ago in response to Judge Thacker's question, it's not uncommon for criminal defendants to address comments to the court about their family or even address the comments directly to the family members present in court. And that can influence the court's decision. Indeed, this very court.
This allocution went on longer than most. It was not an abbreviated allocution.
Well, it took him 4 pages of transcript to get through his first 2 topics, even with the
He was very thorough with the judge. I mean, he recited paragraph after paragraph of his allocution to the judge.
The first part of it.
And Judge Osteen was patient with him. Judge Osteen been around a while too. He's been through a few of these things.
He has done.
As a lawyer, very, lots of criminal defendants were represented by young Bill Osteen.
Yes, they were. Yes, they were. And so he has the experience not only as an advocate, but also extensive experience on the bench. It's simply our position that in this case, he should have let the defendant.
Page 34 and 35, your client filled up the whole page of transcript. 36, almost the whole page. In the middle of the page, the judge says it's your opportunity to speak. You make a decision what you want to speak about.
Yes.
Page 37, the same thing, full of allocution. 38, really full. I mean, he did a lot of allocuting, but you said it wasn't enough. That's a question here. What's enough? Are we reviewing this for abuse of discretion?
We contend that it should be reviewed for abuse of discretion.
You can think that's your position.
That's our position.
I suspect that's the judge's or the government's position too.
Is the letter in the JA somewhere?
It's not.
So how do we know it wasn't, that it wouldn't have been repetitive?
Well, he hadn't,
Not to mention that perhaps not relevant because it was to his mother and not to the court.
well, as far as not being repetitive, he hadn't talked about his relationship with his mother, the impact of earlier difficulty or the more recent, closer relationship. So we know it's not repetitive. As far as being irrelevant, we would contend that whatever he says is going to be relevant one way or the other. If it is a heartfelt apology to the mother for the pain that his own criminal conduct has inflicted on her, that tells the court something about his character. On the other hand, if it's the other end of the spectrum and it's simply, please remember to feed my pet hamster this way or that way, then that tells something about his character too. It shows a complete lack of accountability or concern. Either way, that's relevant to his character, which is before the court at sentencing. And as a practical matter,
The main message that this individual wanted to get across was that alcohol had ruined his life and that addiction had ruined his life, but that he'd made efforts to overcome his addiction. And that he was sorry about the inflictions that he had imposed upon his victims. That was the message that he wanted to get across. And he certainly got it across. There was no question about that. As I say, the allocution, as allocutions go, this is a long allocution. This was a garrulous defendant. I don't blame him for being garrulous if that's what he wishes, but Judge Osteen was fairly patient with him. He did ask some questions about whether he had had remorse for his victims in the way that he was asking for remorse from the court. And Judge Osteen asked those questions, and that's not a bad thing to have the district court ask questions during allocution. That's not impermissible. You don't want the district court to sit there like a bump on a log and not ever engage with what the defendant is saying, because it would turn it all into just a rote proceeding. But I don't, given the length of the allocation, given the fact that the main message of addiction is the reason for prior crime was, and his efforts to overcome that message was sounded loud and clear. And I don't mean to diminish his relationship with his mother. That's important to each and every one of us. But I'm not sure I'm not sure that has a relevance to sentencing compared to the subjects that were covered in the allocution and the questioning seem much more relevant to the whole question of the sentence and the 3553A factors than the letter to his mother. And I also don't understand what sort of relief we're supposed to give, to just go back to the trial court and read the letter. I mean, that, with all respect to you, my friend, it's not going to make a difference.
I would argue, Your Honor, that it might. Certainly.
Are you saying that then, as a result, your claim for relief is what? That we vacate the sentence?
Vacate the sentence, remand for
You want us
resentencing.
to vacate the sentence, not just let him allocute further. You want to vacate the sentence and start all over. And under your rule, the defendant who's given a right to allocute, he gains control of the courtroom.
Could filibuster.
Well,
And Judge Osteen had control of the courtroom. And he needs to keep control of the courtroom, and he knows how to do that. But he was very patient. The judge, I mentioned 4 or 5 pages, but it went on and on and on.
That's true. It did go.
And, it was one, I've been present in a lot of allocutions, and it's hard to remember one that was this extensive.
This is unique on these facts for several reasons. First, the defendant clearly gave an overview. I have 3 things I want to address. He was only allowed to address 2 of them. Second, of the total length of the interchange between the court and the defendant, half of it, perhaps a little bit more than half, was the defendant responding to the court's questions. And there's nothing wrong with that.
It's a healthy way to do it.
That's a healthy way to do it if the defendant has had the opportunity to say what they want to say. All that the court
You're
needs...
saying that the defendant gets control of the courtroom. He doesn't.
He doesn't get to control the courtroom. He doesn't get to go on with, as this court has mentioned, irrelevancies or repetitions. He doesn't get to, as in the Atwell case, where a tax fraud defendant's being sentenced, say, well, you don't have authority to tax me anyway. He doesn't get to stand there and take up the court's time denying guilt, as in Grady or Gomez-Jimenez or other cases this court has decided. But that's not what happened here. He had something very specific. And as far as the potential impact, this very court has told my client in other cases that what they said to their mother impacted his sentencing decision. And it's not uncommon for defendants to say something to their family and for that to move the court. Moreover, under this court's precedent, and particularly in Cole, and also the 11th Circuit's decision in Prouty, the question is not one of factual probability. Would there be a different result? It's more of a question really of legal possibility. Whether that full exercise of the right to allocation could have led, and that's this court's language, could have led to a sentence less than received. The 11th Circuit's language in Prouty, whether it might affect, and that's been the test of whether there is.
But I like the term that Judge Thacker used, that if we were to reverse here, it would be an invitation to filibustering. And this would be, all kinds of things, and we would essentially handcuff the district court from ever cutting anything off, no matter how lengthy it was, no matter how repetitious it was, no matter how irrelevant it was. If we were to reverse a district court on this, the district court would not be able to exercise the kind of control over allocution that district courts regularly exercise over things such as the scope of cross-examination and witness testimony, which is a subject to rules of relevance and repetition under the federal rules of evidence. And you, sir, are trying to have rules for allocution that are separate and apart from the rules we have for other parts of a trial or a criminal proceeding. And it doesn't seem to me like a very happy road to travel. But
I understand, Your Honor, I'm out of time. I do have 5 minutes left, and I'll certainly be back to address that point.
you've got some rebuttal time, so
Yes.
we understand you've reserved that. Ms. Niemeyer?
Good morning, and may it please the court. Julie Niemeyer for the United States. I think we're all in agreement that this was a lengthy allocution. The defendant spoke for almost 10 pages of the transcript.
I mean, it is an important right.
Absolutely, Your Honor.
I think Judge Osteen was a very fine district judge. He treated it that way. He said, this is your chance to say what you want to say. That's what he said. And that he didn't downplay the right. He didn't give it the back of his hand and said, oh, that's no big deal. Because it is a big deal. You know, it's very basic to the perception of fairness in the criminal justice system that someone have a chance to say his or her piece. And that matters a lot, to be able to address the court. But Judge Osteen, he took it as an important right and as a serious right. He didn't try to, minimize it or dust it off or something like that, because it is important.
Absolutely, Your Honor. I think this elocution and the interactions and the colloquy with the district court could be excerpted in a textbook on how allocution should be addressed. And I think the length of the allocution and the very nature of the district court's questions and conversation with the defendant demonstrate how closely the district court was listening and how sincere the defendant was in his allocution. And the district court credited that, took it seriously, and the questions reflect that. The district court commented about the progress that the defendant had made in overcoming his addiction and in trying to get past that when he made his sentencing remarks just a few minutes later. So I think this allocution was appropriate. It was limited in a very reasonable manner as to this one letter to the defendant's mother after the defendant had already been speaking for an extended time and had addressed several important topics in mitigation. And the district court was not unaware of the importance of the issue of the relationship between the defendant and his mother, because earlier in the hearing, the district court had addressed that very topic, the importance of his relationship with his mother. And the district court commented on how much credit he gave the defendant's mother for the attempts that she made to get the defendant back on a better path. Your Honors, I'd like to just for a minute address the issue of the standard of review, because this case should be reviewed on the plain error standard. And that's a very difficult standard to meet.
You think the lawyer had to...
Pardon me, sir?
You think that his defense lawyer had to say something?
I do, Your Honor.
He wanted to appeal that, and that's the rule, isn't it?
If a defendant is represented by counsel, it's counsel's role to preserve the objection.
It's not up to the defendant to object.
Right, Your Honor. And I think it's interesting in looking at
the defendant could offend the judge.
Certainly, Your Honor. That's...
Judge, you're not allowed to stop me. I need to be able to speak longer. That's his lawyer's job.
Yes, Your Honor.
Plain error review makes more sense, but it's the abuse of discretion comes in here somewhere too, doesn't it?
Well, when we're evaluating, Your Honor,
you have to find a plain error.
Exactly. When we're asking,
plain that the court erred in telling him to, or stopping him from his allocution.
Yes, Your Honor.
That would be an abuse of discretion. Then
Right.
it would have to be prejudicial. What did he get, 110 months?
Yeah, 120 months, Your Honor.
120 months.
Interestingly,
And he could have gotten more than that.
well, he was limited by the statutory maximum in this case. But it's interesting because the judge made comments on that very subject when announcing sentence. The judge said, and this is at...
there were a lot of violent instances that were...
That's right, Your Honor. And so...
situations that were discussed.
In discussing the 3553A factors, the court highlighted the extreme seriousness of this offense and the need for protection of the public, because in this instance, an innocent member of the public suffered gunshot wounds because this particular defendant, who never should have had a firearm in the first place, had discharged a firearm, not just possessed it, but discharged it. And so in discussing these issues, the district court actually comments on Joint Appendix 89, I think there's an argument that if I had the authority under the current state of the law to impose up to a 180-month sentence, that arguably this would be a case that would require a sentence of 137 months, which was the top of the guidelines in this case, or perhaps even higher than that. But the statutory maximum establishes a limit. And so this record just clearly establishes that there is not any possibility of prejudice in this case. The defendant was not authorized to have a firearm, discharged a firearm, injured an innocent citizen.
No, if we have plain error review, I'm not saying whether we should have said, but it's always open to the court to say there was no error at all without getting into prejudice.
Absolutely, Your Honor, because I
And
think...
say there's no error,
Absolutely.
much less no plain error.
Yes, Your Honor, the record speaks for itself.
It doesn't get past the first prong of the plain error standard. That's the government's
That's the government's position, yes, Your Honor. If the panel has any further questions, I'd be happy to address them. If not, the government requests that the decision be affirmed.
Do you have further questions? Stephanie? Thank you. All right, Mr. Plackey, you've got some rebuttal time.
Thank you, Your Honor. Your Honor, the government points out that the defendant and the court engaged with one another for about 10 pages. The difficulty is that most of that, close to 6 pages, is the defendant responding to the district court's questions. It's not the defendant getting a chance to say what he wanted to say. I understand the court's concern about approving a filibuster, but again, that's not this case. The defendant said, I have 3 things I want to say. It took him 4 pages to cover the first 2, even with a couple questions from the district court. There was no reason for the district court to think that he was just going to go on ad infinitum. He had one more thing he wanted to talk about, and based on, essentially 2 pages per topic, no reason for the district court to think he was going to go on at length. And that's why we believe it was error in this case. Now, again, yes, Your Honor.
We don't want to have a situation where district courts are required to just let allocution go on and on and on and on. I mean, as important as the right is, it's got to be subject to certain limitations. And the district court, not the allocutor, has got to be the ultimate authority in this. If we reverse this, we would simply be turning over the courtroom to an allocution, no matter how endless, no matter how tangential. And I think it would have been a much stronger allocution case if the district judge had been abrupt and just cut it off before an individual had a fair chance to plead for mercy. But that isn't what happened here. This was an engaged district judge and a patient district judge, both patient and engaged. And the proceeding went pretty doggone well.
Your Honor,
And you didn't think so bad about him that you objected.
I did not object.
You did
Again,
not object. You say that he preserved it himself.
that's our
But
position.
he wasn't representing himself.
No, he wasn't. I was
So it was
representing.
your job to object. I mean, I don't mean to dump blame on you, but that's what the defense lawyer is supposed to do.
No, I understand exactly, Your Honor.
I've represented a few people myself. If you think the judge is out of bounds, you've got to say so. That's your job.
That is my job at that point.
Then it
Yes,
comes
is,
up
Your Honor.
on harmless error review. She pretty solid in taking position as plain error review. And that's a tough test anyway. But whether it ever gets there, I don't know whether that makes any difference. I'm not saying.
Well,
Probably doesn't make any difference.
I understand, Your Honor. Again, we maintain that the defendant's repeated requests 3 times with 3 no's from the court was,
Preserved it.
excuse me,
You say that preserved the issue.
which is exactly what the Ninth
I
Circuit,
thought that you were saying that well, it preserved the issue and that was the error.
I'm
You're
sorry.
saying that was the error. The judge interrupted him before he could give his 3 answers or whatever it was, make his 3 points.
Well, no,
The
he,
judge lost patience with him or whatever you were saying. Whatever it was, the defendant said enough to preserve the error.
well,
That's not his job. That's your job.
well, there were 3 topics, but then as we get to the 3rd topic, 3 requests and 3 no's from the district court. And under Lee, it's our,
And his lawyers stood mute.
his lawyer's assessment of the temperature of the courtroom, which I think is important, was to proceed on and not to raise it at that point. Yes, Your Honor. And if that means
Practiced before Judge Osteen
many times.
many times. And he's not an intimidating person and lawyers in the courtroom. He stood in your shoes.
He
He's
has.
done that. He's been there, done that. Many times himself.
He has. And
Right.
it's simply an assessment of what's best for the client at that moment in time. I'm out of time, speaking of time.
All right, we thank you, sir. We will adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.